may be more, which today may be more challenging than usual. So let's start with the usual. Commissioner Baker.
Present.
Commissioner Bluestone.
Here.
Commissioner Carruthers.
Here.
Commissioner Castillo.
Here.
Commissioner Solomon.
Present.
Commissioner Villanueva.
Here.
And the chair is present. So item 1 is accomplished. Should we take a break or move on? Number 2 is approval of the agenda. Jeremy, do you want to speak to that for a second?
Yes, thanks, Chair. So commissioners, I believe the agenda needs to be slightly modified so that the commission can decide on its next regular meeting in May before going into executive session. So I would just ask the commission modify the agenda in that way. And I want to alert the commission that the agenda that was posted includes an item to announce the settlement between State Ethics Commission and Working Families Organization. And just so that we maintain a good record, if the commission could just make clear that's on today's agenda as well. So those 2 items, Chair, thank you.
Thank you. Is there a motion and a second to amend the agenda as suggested?
I'll so move. Second.
Thank you. And with those amendments,
I have a question, Judge.
go ahead.
I remember I emailed Jeremy about possibly arranging for public comment both before and after we go into executive session. I think that was a recommendation we had from, maybe it was Tony Ortiz, somebody before, but it seemed to make sense to me that rather than having the public wait for what could be an undetermined period of time in our executive session before they're allowed to make any public comments, that we should do it before we go into executive session and possibly after as well. And I thought Jeremy indicated he agreed with that, but I don't know if it's been on the agenda. I haven't seen it.
It is on the agenda.
Okay, it's
Okay.
just not on the one I have, I guess. Okay,
Great.
Thank
And
you.
The chair will, just for his prerogative, if we enter into somebody who wants to publicly comment before and after at the expense of the genuineness of the meeting, I will exercise whatever prerogatives may become necessary. I don't see that as a problem, but just so you know. All right. So with that, Commissioner Baker, approve?
Yes, sir.
Commissioner Bluestone?
yes, yes.
Judge, you're mute.
How did I get, I don't know how I got muted. I didn't touch anything.
Yeah, I got muted too. Did you hear my yes?
I did. Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes, the agenda is approved. Now on to item number 3, approval of the minutes of our last commission meeting, which was on February 3rd. Motion and a second.
So moved. Second,
Okay, any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
yes,
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
and Commissioner Villanueva.
Yeah.
Chair votes yes. Motion carries. The minutes of the February 3rd meeting are approved. All right, on to item number 4. Advisory opinion 2023-03. Jeremy?
Thank you, Chair. Commissioners, this advisory opinion deals with treatment courts, also known as drug courts, in the anti-donation clause. Treatment courts have been a part of New Mexico's adjudication of criminal matters since 1995. It's a diversion program, and the evidence is that it's a very successful system of adjudicating drug-related crime. The question presented is, whether the services and the supplies that treatment courts provide to treatment court participants, such as exercise classes, limited gym memberships, personal hygiene products, gardening supplies, etc. Whether or not those benefits are donations in violation of the anti-donation clause. The question presented is it's a real one because we're under the understanding that unless the Department of Finance and Administration has a legal opinion on this matter with respect to the anti-donation clause, that there's some reluctance there to approve purchase orders for these items that treatment courts are supplying to treatment court participants. The draft advisory opinion concludes that these benefits that treatment courts provide to treatment court participants are not in violation of the anti-donation clause for two reasons. First, it's uncertain whether or not these types of supplies and services that treatment court participants receive as part of their participation in treatment court are donations in the traditional sense of the term, given the coercive context in which those services and supplies are received. But even if they were donations within the scope of the anti-donation clause, the draft advisory opinion concludes that the first exception of the anti-donation clause, that the constitutional prohibition doesn't apply to any provision for the maintenance and care of sick and indigent persons, that exception applies here, and thus even if they were donations in the sense of the anti-donation clause, that they're accepted from the clause prohibition. The constitutional language, sick or indigent, following Supreme Court case law on the interpretation of that term, those terms aren't anchored to what they meant in 1912. And in a modern understanding, I believe, of that constitutional term, these individuals who are participating in treatment court, they're suffering from serious disorders. They're suffering from drug and alcohol disorders. And in the modern interpretation of and application of that term, I think the exception applies to exclude these supplies and services from the anti-donation clause's scope. And so for that reason, Chair and Commissioners, the draft advisory opinion concludes that the anti-donation clause does not prevent these expenditures for treatment court participants. And I'd ask for a motion to approve it.
Is there a motion and a second?
So moved. Second.
Thank you. Any discussion?
I'd like to make one comment.
Sure.
I think that the opinion is very well done, and I thank you for it, Jeremy. I would just like to say that when the opinion notes that at the outset, it's not obvious that these services and benefits are donations because of the consequences that can happen if people don't participate. But I would also feel that they're not, the state is receiving consideration. The state is receiving, in the legal sense, consideration by these people participating in the program and benefiting from the program. And I don't think I'm not going to move to amend the opinion, but rather than say that it's uncertain whether these are even donations at all, I would personally believe that they're not donations because the state is receiving legal consideration by having these people participate in the drug court program and getting the benefits that the state is trying to derive from the program. So I would go a little further, but I'm not so committed to that position that I feel I want to ask for the opinion to be changed, because I think it's also correct that even if they were donations, the anti-donation clause does not apply. But I don't think they really are donations because of the consideration that the state gets in return for them. Thank you.
Thank you. Thank you. Anyone else?
Yeah, real briefly, as I understand it, what triggered the request to the Ethics Commission was DFA saying we don't want to approve this without a legal opinion saying it's appropriate. Is that correct?
Chair and Commissioner Baker, that's my understanding of how it made its way here.
And I don't have any heartburn with state agencies asking the Ethics Commission for legal opinions, but doesn't DFA have its own lawyers?
Chair and Commissioner Baker, they do.
Well, I'm not going to suggest today that we send them a bill for your work, but
Well,
make the
we
point
kind of
that
owe them.
they have
for
their own
stealing
lawyers.
them. We owe them for stealing Jeremy, so we're even.
Fair enough.
Okay, anyone else? You're not, Commissioner Baker,
I approve.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon. Commissioner Solomon,
Yes, sorry, I was muted.
that's okay. Well, you screwed me up here in my office. Commissioner Villanueva.
Yes.
And chair votes yes. Motion carries. Let the opinion issue. Thanks, Jeremy. Nice work. All right, on to the next matter.
Okay, thank you, Chair. Commissioners, the next matter is a rulemaking that the commission should conduct following legislation that just occurred in the 2023 legislative session. Before you is a notice of proposed rulemaking, and after I go through the notice, I'll ask for a motion that the notice of proposed rulemaking be issued so that it can be published in the New Mexico Register in time for a rulemaking that would occur at the commission during the second meeting in Las Cruces at the Department of Agriculture at 9 a.m. The proposed rulemaking would amend two parts of the commission's rules, part 1.8.1 and part 1.8.3. I'll start with 1.8.3. That's the commission's rules of procedure for administrative complaints that are filed with the commission, and it's the rules of procedure for how those administrative complaints are reviewed for jurisdiction, investigated, under which probable cause determinations are made, how hearings are conducted. It addresses subpoenas that the commission can ask from a district court, and then it also addresses the appeals of administrative cases. As you know, the legislature passed a bill this past session, which the governor signed, HB 466, and that legislation made a slight modification to the Ethics Commission's procedure in how the commission staff, principally the general counsel, determines probable cause. The adjustment was before HB 466, if the general counsel determined that a complaint is supported by probable cause, 30 days after that determination, the complaint in the administrative record would be made public, and a hearing with a hearing officer would be set. The legislation requires that if the general counsel determines that a complaint is supported by probable cause, that an independent hearing officer also has to make that same determination. And if an independent hearing officer determines a complaint is supported by probable cause, then 30 days subsequent to that determination, the administrative complaint and record is made public, and a hearing is set with a separate hearing officer. So the legislation requires two separate hearing officers for the full adjudication of administrative matters with the State Ethics Commission. And because of that legislative change, the commission needs to make a change to its rules to conform. So that's the main change in 1.8.3. Part 1.8.1, which is the Commission's general rules. The proposed amendment there is really to bring in and codify in rule what the Commission has been doing by resolution since its inception with resolution number 4 in 2020, which is the process by which the Commission exercises its executive discretion to commence civil enforcement actions in the state courts to enforce the statutory provisions that the Commission has the authority to enforce. So the main amendments to 1.8.1 bring that process into rule, and also address the Commission's ability to seek leave from a district court for subpoenas in anticipation of those civil actions during the investigation of those civil actions. And so that's the bulk of the proposed amendments to part 1.8.1. And then last, the Commission, this notice of proposed rulemaking would create a new part, 1.8.5, which would be the rules of procedure for administrative complaints that the Commission receives that allege violations of the revised Uniform Law on Notarial Acts. So the Commission, since the beginning of last year, has been investigating and adjudicating complaints against notarial officers. And the purpose of 1.8.5 is just to bring that procedure into rule and codify it in rule. And that also follows legislation that passed in the previous session. There was a bill that expressly gave in Relona the Commission rulemaking authority to design rules of procedure for those cases. And so, Chair and Commissioners, the notice of proposed rulemaking is that at the June meeting, the Commission will hold a rulemaking hearing for those rules. A draft of the rules have been up on the website for Commissioners' comment. Following the publication of this notice of proposed rulemaking in the New Mexico Register, we'll make the rules available on the Sunshine portal. We'll also make the draft rules available on the Commission's website so that the public has ample opportunity to comment in writing or to come down to Las Cruces and participate in the rulemaking. And so with that, Chair, I'd ask for the Commission to issue the notice of proposed rulemaking.
Is there a motion and a second to?
So moved. Second.
Thank you. Moved and seconded. Any discussion? Okay, hearing none, the motion is set for a vote. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes,
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Thanks, Jeremy. We'll go ahead and issue those, and we will take them up at the June 2nd meeting.
Thank you, Chair.
Thank you. And then the next matter is item number 6, settlement terms in State Ethics Commission versus Working Families. Jeremy, you want to lay that out for us,
Sure.
please?
Thank you, Chair. So Commission, I'm very happy to announce that the Commission has completely settled its lawsuit with the Working Families Organization. The Commission has received all of the performance from Working Families Organization on the terms of the settlement. That includes an $11,000 civil penalty, which we received from Working Families last week. And it includes Working Families filing a report of independent expenditures and contributions for independent expenditures with the Secretary of State's office. Commissioners, this was a matter that arose because Working Families Organization was participating in a text message campaign advertising campaign in support of New Mexico's ballot initiative to increase the distributions from the Land Grant Permanent Fund a ballot question that was on the November election and the previous general election. Those text messages, that text messaging advertising campaign that went to many New Mexicans, those were advertisements under the Campaign Reporting Act. And as such, the person who authorized and paid for those advertisements had to say so in the advertisement, and also be subject to the reporting requirements for independent expenditures under 119.27.3. The text messaging advertisements purported to be from a group, Unemployed Workers United. And because it was unclear that it was actually the Working Families Party, which is based out of Brooklyn, New York, there was also a concern under Section 119.34.3 of the Campaign Reporting Act about who is in fact the true source of a campaign advertisement. So because that text messaging advertisement campaign, in our estimation, violated several provisions of the Campaign Reporting Act, the commission authorized a lawsuit, which we filed in the 5th Judicial District Court, and without needing to litigate, we reached a favorable settlement with Working Families. I want to commend the work that Walker did in this case, and the work he did in shepherding it and negotiating the settlement. Walker did a fabulous job on this case. And it's the filing that Working Families Organization made to the Secretary of State's office. They disclosed the donors, the contributors to Working Families Organization, whose donations, contributions were used for the text messaging advertising campaign. And it's quite interesting. There were some labor organizations from around the country, but what we're beginning to see follows, I think, a lot of other campaign reporting enforcement agencies around the country, is that when we pursue disclosure requirements for large political campaigns, it's often the case that the donors or the contributors that we force disclosure of, it's just nonprofit organizations, other kind of organizations that receive donations themselves. It's rare, I think, it's becoming increasingly rare that when we enforce a disclosure regime, that we actually are able to show the participation of a particular individual or a particular corporation. And this is kind of an increasing focus of academic commentary in the campaign finance area, and it maps with what we're seeing, the use of nonprofit corporations, 501c3s, 501c4s, really as ways to, for lack of a better word, hide the ultimate donations that are made for political purposes. I don't know what to do about that, and I'm not sure that anyone has a good solution for it at the moment. Alaska is working on some interesting initiatives in this area, but I just want to mention that this case and what we observed with the performance of Working Families Organizations settlement terms, it does align with what this legal community is seeing around the country in terms of actually forcing the disclosure of a corporation or an individual that's supporting a political cause or a candidate. So, Judge, with that, that concludes the presentation of the settlement. I don't have, I'm not asking for a motion for this. It's just an announcement.
Anyone have any questions?
Yeah, go ahead, Stuart.
Okay, thank you. On that point that Jeremy is raising about the inability to really learn the disclosure of the names of the individuals who are contributions that are made to these to prove, but I do have a question that I'm aware of Reporting Act that can't make
Stuart, you're breaking up. It's tough to
Yeah.
hear you.
We're getting about every third syllable.
I may have off these earpieces. No.
Yeah, now there's nothing except the look of
Frustration.
frustration. Thank you. Having said that, that's a fine segue into your comments, Jeff.
Yeah. Jeremy, what is the name of the case that was before Judge Starzinski?
An administrative case that
Well, the one where he said that the commission did not have jurisdiction.
Commissioner Baker, that case might not be subject to public disclosure.
All right. I thought because it was in front of Judge Starzinski in district court that it was a matter of public record.
Judge Ramzik, I think is what.
Oh, Ramzik, I'm sorry.
Okay. Ramzik, thank you, Chair. Commissioner Baker, the case before that was before Judge Ramzik that is now on appeal is that's the New Mexico State Ethics Commission versus New Mexico Working Families Forward.
Right.
Can you hear me now?
New Mexico Families Forward.
Yes, Stuart, you want to say something?
Yeah, it was just a brief point. I apologize for this problem here with the earpieces, but there is a provision in our Campaign Reporting Act that says nobody can make a contribution with the intent, which may be hard to prove, to conceal the names of the people who are the real source of the funds for dark money contributions. So we do have that provision in our law, but as I say, it may be a very difficult one to prove. But it's in 11934.3 subsection B. And I know Jeremy's aware of that, but it can, as I say, it can be a hard thing to establish to prove the intent. But we have some provision in our law that's trying to get to the disclosure of the real source of the funds.
Thank you, Jeff. Did you have anything else, or did you just want that clarification?
No, I just wanted to ask the question. The case that we settled, were the legal arguments essentially the same as the case in front of Judge Ramzik?
Chair and Commissioner Baker, not at all. The case that we settled with Working Families Organization was a case that was brought under the Campaign Reporting Act. The case in which we are appealing Judge Ramzik's decision as against New Mexico Families Forward is a case about a disclosure provision under the Lobbyist Regulation Act, Section 6I of the Lobbyist Regulation Act. So different statutes, different provisions, a different case.
Okay, thank you for that. The only other thing I would say is that number one, congratulations to Walker and to the legal team for getting that settlement with Working Families. And I would encourage you to get as much publicity about that as possible.
Thanks, Chair and Commissioner Baker. I'm under the impression that the journal reporters, Dan Boyd or Dan McKay, have asked about the settlement terms, and so I believe that there might be a story.
Thank you.
Thank you. Anyone else? Okay, if not, thank you, Jeremy. We'll move on to the next item, which is that aforementioned public comment session. If there's anyone wishing to make public comment addressing the issues that have been discussed today, prior to our entertaining a motion and likely going into closed session, please signify to the administrator today by raising your hand, and you will be recognized. Sue, I assume that is you, and I will, or I don't know who it is. I will back that assumption off.
So I can do the honors. So we have Mr. Chris Meckles. Mr. Meckles, I'm going to ask you to unmute, and I'm going to ask you to start your video.
First, is my audio okay?
Yes, sir.
Okay. Well, good morning to the commission and Jeremy. The first thing I want to say is I commend you on moving the comment period forward. I've long thought that's a problem because there's just too much variability in your schedule to make it for the late comment period to be that useful. So I would hope that you maintain the 2 comment period, which I look very useful. If not, if you only want to have one, I'd suggest the early one rather than later is more convenient to the public. I'm quite interested in the workings of the Ethics Commission, and I found that to be not very workable. So I commend you on moving it. I really appreciate that. A couple of other quick points. One of it is I noticed you've got a rule. The rule meeting is set for Las Cruces. It's not clear from your announcement whether that will be Zoomed. I hope that it will be because I'm interested in rule hearings, and I certainly don't want to drive down to Las Cruces for the privilege. So a Zoom meeting would be very nice, and especially it also is. I have hearing issues, which I'm wearing, which is why I wear this headset, and that also helps me with my hearing. Lastly, I know that most of this, what I'm going to say next is I'm going to discuss a real problem in our state. And I noticed that unfortunately most of this is currently outside of your range. There's a real problem, and it seems like it's coming up again with the new occupants of the Attorney General's office and the Secretary of State, et cetera, is the public, including myself, has a real problem with enforcement of the Open Meetings Act, the EPRA Act, and especially the Rules Act. It is nearly impossible to find an attorney, especially to take a Rules Act case as a private individual. It's just not attractive financially to attorneys. So unless the Attorney General sees fit to act in enforcing OMA, EPRA, and the Rules Act, they basically go unenforced, and the government does whatever they want, and sometimes it's pretty ugly. One of my favorite examples of what I maintain is an illegally implemented act is the Cannabis Act. It is rife with rulemaking violations and has never been challenged. So I'm just saying this is a real serious problem, and I think it's becoming more serious because the court now allows attorneys to sort of buy out of their obligations to public service. So which made the situation, or I think at some point this needs to be addressed because the public is being shut out. The Attorney General doesn't enforce in many of these areas, and we're just left with basically lawless behavior on the part of the executive branch going unchallenged. I think it's very unfortunate, very bad for the state. And I'm raising this concern because I know that it's not on your plate currently, but I trust that you do have some influence in the state. So thank you. Thank you for paying attention to these comments, and I applaud what you're doing, and I hope to look in on you in the future. Thank you.
Thank you, Mr. Meckles. Anyone else? Again, please, if you'd like to comment, please raise your hand. Jeremy, I can't see it on my.
I believe Mr. Meckles was the only comment today.
All right. In which case, one item prior to moving or seeking a move into closed session, as Jeremy indicated at the top of the meeting, you're going to need to have a special meeting sometime in May. And let's do that now for a variety of reasons. Again, if people want to sign off, as with the public comment section, they don't need to wait around to find out when that is. Jeremy, did you have any particular date in mind?
Chair, I do not. The staff will be available for whenever the commission sets this.
All right. Well, historically, we've fallen into the Friday morning routine. So if we all can nod agreement to that, that'll reduce the number of dates and discussion, which leads us closer to a Yahtzee.
If Friday morning is okay with me, the only Friday I cannot do it is the last Friday in May, the 26th.
Mr. Chairman, I have May 5th open. That would be a good day for me.
Yeah, I'll be traveling back to Santa Fe from probably Arizona that day, so I would rather not do it that day. I mean, if need be, I could try to do it by phone while we're traveling.
What about the 12th?
12's good for me.
Yeah, I could.
12's good for
I
me.
have a doctor's appointment that's been long scheduled at 1 o'clock that day, but I could try to reschedule that, I guess.
Yeah, we'll go in the morning. I hopefully be done by then.
Okay,
So May 12th, 9 o'clock, Zoom.
It's good for me.
All right. Thanks, everybody. May 12th, 9 a.m. Special meeting. With that, is there a motion and a second to go into closed session to discuss those items which are specifically allowed to be dealt with in closed session?
So moved.
Second,
Thank you. Commissioner Baker,
Yes.
Commissioner Bluestone,
yes.
Commissioner Carruthers.
Yes.
Let's see here. Commissioner Castillo,
yes.
Commissioner Solomon,
Yes.
Mr. Villanueva,
Yes.
and chair votes yes. We are now going to go into closed session. All right. I take it we are back in open session. Jeremy, you're still muted.
We are, Chair, and I believe we're all here.
Okay. So, we are, and Commissioner Castillo, thank you for acting as I had requested you to. Number 10, actions on administrative complaints.
Thank
Jeremy?
you. Thank you, Chair. The staff seeks a motion for a 90-day extension to continue the investigation in administrative complaint number 2022-027.
Is there a motion and a second?
So moved.
Second,
Thank you. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers is excused for this last part of the meeting. I excused him earlier. So Commissioner Castillo,
yes.
Commissioner Solomon,
Yes.
and Commissioner Villanueva. Judy? You're muted.
I saw her mouth say
There you go.
yes.
Yeah, I see that. I was gonna say, just give me a thumbs up and I'll record that. So motion carries. Thank you. Let the extension is granted. Okay, and B?
Thank you, Chair. The staff seeks a motion for a 90-day extension in administrative case number 2022-045.
So
Okay, there's a motion,
Second,
motion is second. Any discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers is excused. Commissioner Castillo,
yes.
Commissioner Solomon,
Yes.
and Commissioner Villanueva.
Yes.
Thank you. Chair votes yes as well on both. Okay. The next item is item number 11. Jeremy?
I believe Commissioner Bluestone has prepared a motion.
I have.
Thank you.
Given the recusals of Chair Lang and Commissioner Carruthers, I move that the executive director be directed to contact a list we have provided of pro tem commissioners to consider commission authorization of a civil action regarding violations of the Procurement Code and the Governmental Conduct Act by state officials and employees.
Okay. Is there a second?
Second.
Second,
All right. Any discussion? Hearing none. Commissioner Baker,
yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers is recused. Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and the chair recused on that. So that motion carries, and we'll let that proceed accordingly. Discussion of the next meeting. We did agree earlier, prior to going into closed session, that the next meeting would be a special meeting and it would be conducted on May 12th. And the next regularly scheduled, beginning at 9 a.m. on Zoom. And the next regularly scheduled meeting will be via Zoom. Actually, it'll be in Las Cruces, but we will make the usual effort to provide input and access remotely for others. And the meeting will be in Las Cruces at the Department of Agriculture. And any details involving perhaps honoring our soon-to-be departed commissioner from Las Cruces will be forthcoming. Anybody have anything else on the issue of next meetings? No? Okay, again, public comment. Anybody have any public comment to that vast amount of information that we have just conveyed in this brief reopened? Anybody raise your hand if you've got something, please? I don't see anything. Do you, Jeremy?
No, Chair. If anyone would like to make public comment, please indicate so by raising your hand. Seeing none.
I've got a question. I just want to make sure that I followed this properly. The chair mentioned the June 2nd meeting in Las Cruces
Correct.
and mentioned the May 12 Zoom meeting
Right,
in Albuquerque.
right. What's the Zoom meeting? Yeah. it's a
Yeah,
Zoom
we have a
meeting.
meeting on April 20.
We don't know
Not
yet.
that I'm,
Okay, got it.
oh, that's outside of my.
Provisionally. But
Got
we
it.
will notice a special meeting on the agenda, on the website.
There's
Thank you.
there's good reason why I don't know what you're talking about, because I wasn't there, right? Plausible deniability. Okay, anybody have anything else before we call it a day?
Yeah, I just want to commend Judge Castillo for her service as the chair. She was very impressive. And if I was a particular retired judge, I might get a little worried about whether I might be have my position usurped.
She is welcome to it, dealing with the likes of some of the commissioners.
Well, I want to thank the commissioners for being great commissioners. It was a pleasure.
Good. Thanks again for doing that, Judge Castillo. All right, there being nothing further, we will stand adjourned. Everybody be well until next we meet.